was on the agenda. And I'm glad today that we are continuing in this process to have access to justice. And if I'm not mistaken, it's maybe the 27th or 28th bill of the Attorney General before this House to enhance access to justice with such a comprehensive piece of legislation again. Madam Speaker, the major change, the fundamental change being brought through this bill is the full centralization of disciplinary intake and investigation. Honorable Ramdas spoke about clause 4, whereby the establishment of the Practitioners' Complaints Commission, and also complemented by clause 8, subsection 2, with regard to any complaint addressed to the Bar Council, to the Mauritius Law Society, to the Chamber of Notaries, or even the Attorney General, must be promptly referred to the Commission. In the legal profession, Madam Speaker, there are a few that apprehend this piece of legislation. They thought that this is a radical shift or change from what we are used to, that is self-regulation. But I would like to take a few examples so that our fellow lawyers will understand that the trend is for reform. And this is being done in many Commonwealth countries. So this is not a radical proposition. This is in line with what many Commonwealth countries have been doing for years now. We take the example of Australia, Madam Speaker. Each state and territory has a Legal Services Commission. These are statutory bodies completely independent from bar associations. Their mandate is to investigate, mediate, and if necessary, prosecute legal misconduct before independent tribunals. In the same vein, Madam Speaker, in New Zealand, they have got the Lawyers and Conveyancers Act of 2006, created a single entry complaints service managed by the New Zealand Law Society, but decisions are reviewable by the Legal Complaints Review Office, an entirely separate and impartial body. In South Africa, Madam Speaker, they took the bold step through the Legal Practice Act 2014, which established the Legal Practice Council, a unified regulatory authority overseeing all legal practitioners. It ensures that the public can lodge complaints in a transparent and efficient manner. Even in Canada, Madam Speaker, in Ontario, the Law Society functions as both a regulator and a complaint handler, but decisions are made by disciplinary tribunals with strict rules of independence and lay participation. So this is not something out of the blue. This is the trend with regards to the modernity that we are bringing in the legal profession. The Honorable Attorney General pointed out, we've got more than 1,600 lawyers now. And Honorable Ramdas, he's not here, has been saying that, he's here? Okay, yes. Okay. So around 100 lawyers are being called to the bar almost every year in Mauritius. So the legal profession is a blend of old, new, and newcomers with speciality in very specific fields.
It was 50 when I started.
50, okay. 50.
Yes, only 50.
So all these, Madam Speaker, bring us to what we need, reform. And this piece of legislation, well drafted, is part of this process of access to justice. And, Madam Speaker, there is a very important clause that I would refer to. I will not be repetitive to what Honorable Ramdas and the Honorable Attorney General said, but I would like to specify on clause 9 of the bill. It empowers the Commission to dismiss complaints that are frivolous, trivial, and vexatious. This is an essential filter because, Madam Speaker, unfortunately in Mauritius, we've got a few jack of all trade and master of none. They know the profession more than others, and there are so many adverse comments because they do not know how the profession functions. For example, you take the cab rank rule. For many people, they do not know the basics of this important rule, because this is for lawyers, and I must admit that at the level of the bar, we need to disseminate, we need to educate, and we need to give proper guidance as to how our profession is all about. So this imported filter is something that is very commendable, and this is also mentioned in clause 8 subsection 2, whereby all complaints would be now directed to the Commission. Now, what are the risks, the practical issues? The practical issues is the Commission may risk becoming administratively overburdened. Why I say so, Madam Speaker, is that this practical issue is already well documented internationally. A significant proportion of complaints received by legal regulators worldwide relate to delays, communication issues, or fee disputes, none of which constitute misconduct. That is why I would here make a proposal. There is in the United Kingdom the legal ombudsman. I will call it the legal ombudsperson. So over there in the United Kingdom, Madam Speaker, service quality complaints are handled by the legal ombudsman, allowing disciplinary bodies to focus solely on allegations of ethical or professional breaches. Similarly, New Zealand, Madam Speaker, separates preliminary assessment and service complaints from serious disciplinary matters through the lawyer's complaints service. Introducing a similar mechanism here, whether now or at a later subsequent phase, could greatly enhance the efficiency and clarity of the system. And why I say so, Madam Speaker, with the establishment of a legal ombudsperson, this would bring three major benefits. It would firstly educate the public about the distinction between misconduct and service complaints. It would also filter out non-disciplinary matters, ensuring the Commission's resources are used appropriately. And thirdly, to protect the Commission from becoming overwhelmed, allowing it to concentrate on serious misconduct as intended by this bill. The Commission's mandate, Madam Speaker, as structured under clause 8 to clause 14, is to assess professional misconduct. A complementary mechanism to deal with service issues would ensure disciplinary system remains accessible, efficient, and fair. So this is the proposal I'm making to the Honourable Attorney General, and this goes in line with what we call the Commonwealth Latimer House principles. These are guidelines with regards to promoting good governance, democracy, but also rule of law, access to justice, and most importantly, the independence of the legal profession. And in this vein, I would humbly invite the Honourable Attorney General to consider this suggestion offered in a spirit of constructive reflection, because I do not want to detract from the merit of this bill. Rather, the aim is to reinforce effectiveness with regards to a balanced, independent, efficient, and capable of maintaining public trust in this new Commission. Because at the end of the day, Madam Speaker, this Law Practitioners Disciplinary Proceedings Bill is a serious and thoughtful reform that aims to strengthen transparency and also to give confidence to the public at large that the legal profession is here to participate in this administration of justice. So I would invite the Honourable Attorney General to kindly consider whether maybe at a later stage we could implement this legal ombudsperson so that we can filter and also disseminate what we could qualify as misconduct, or again other complaints that could be dealt at administrative level. So this is my participation in this debate, Madam Speaker. I thank you for your kind attention.
Thank you. Honourable Minister.
Madam Speaker, 32 years ago, on a cold evening on the 25th of November 1993, I was called to the utter bar of the Society of Buddha Temple. Incidentally, on this very same day, at the very same time, our Honourable Prime Minister was being called at the Inner Temple. In England, every barrister have to be a member of a professional association known as an Inns of Court. We have Lincoln's Inn, Gray's Inn, Inner Temple, and Middle Temple. But what surprised me when I was admitted to the bar is that each of these associations carries the name Honourable Society. So when you are called to the bar, you become a member of the Honourable Society of one of the Inns of Court. Why? Because barristers, as is set out in the very first paragraph of our Code of Conduct, Code of Ethics for barristers, and I quote, honesty, integrity, independence, and strict compliance with professional standards remain constant requirements for all those who seek to practice at the bar. Unfortunately, Madam Speaker, not all practitioners today adhere to these ethical principles. Most of us do, but not all of us. And this bill is providing the necessary legal framework for law practitioners to be held accountable for their action and be subject to disciplinary proceedings where necessary sanctions. So as of today, there are two separate and distinct mechanisms to deal with cases of breach of etiquette, breach of professional misconduct involving a law practitioner. And by law practitioner, I mean barrister, attorney at law, and notary public. First is by self-regulation. So the professional bodies of which the law practitioner is a member takes the sanction. The Bar Council, the Mauritius Law Society Council, or the chambers of notaries have the discretion to investigate any report made to it regarding alleged act of professional misconduct. The professional bodies can then reprimand or severely reprimand a law practitioner. However, they are required by law, and that is very important, to attempt to reach an amicable settlement, an amicable solution, and afford the law practitioner with an opportunity to be heard. Only where after preliminary investigation there is a prima facie case of serious professional misconduct that the professional body refers the matter to the Supreme Court for determination. So that is the first general mechanism. The second mechanism to investigate and institute disciplinary proceedings against a law practitioner rests with the attorney, the Honourable Attorney General. The Attorney General has the power under the Law Practitioners Act, either on his own initiative, proprio motu, or on receipt of a complaint to inquire into any act done by a law practitioner. Where the Attorney General is of opinion that the act done by a law practitioner calls for the institution of disciplinary proceedings, he has to submit a detailed report to the Chief Justice, who then proceeds to hear the matter. So first, there is CF regulation. Second, there is the Attorney General who refers the matter to the Supreme Court. And then, thirdly, there is the Supreme Court itself, under its inherent jurisdiction. It has the power to hear and determine any complaint against a law practitioner under Section 18 of the Courts Act. But as at today, and this is not going to change with this new bill, it is only the Supreme Court that has the power to order that the name of a law practitioner be erased from the roll so that he can stop practicing. And I pose here to reconfort the Honourable Ashley Ramdas that the Supreme Court always acts reasonably when imposing the sanction. In the case of Babulal, for example, the Supreme Court held that the case will be visited by a suspension of 1 year. So they gave a suspension of 1 year. However, since it was the very first case of disciplinary proceeding for such professional misconduct, which did not involve dishonesty, that was the client, the court said that they were prepared to suspend the decision to suspend for a period of 3 years. So the Supreme Court is not going to lightly suspend a law practitioner or remove him from the role. But, Madam Speaker, in practice, and this is, I totally confer with the Honourable Attorney General, the system is not seen to be working. The Supreme Court is rarely called upon to determine allegation of professional misconduct against law practitioners. I have gone through all the law reports. In the past 25 years, there are only 7 reported cases where disciplinary proceedings against law practitioners have been brought before the Supreme Court. 2 barristers and 1 attorney had their names removed from the role of practicing law practitioners, and 1 barrister was suspended for a period of 6 months. Why? Is it because all practitioners are adhering to their code of ethics? Rather, there is a perception, Madam Speaker, that the current mechanism of disciplinary action against law practitioners is not working. Professional bodies, be it Bar Council, the Law Society Council, the Chambers of Notaries, hardly ever report a matter to the Supreme Court for disciplinary proceedings. There is a perception of the lawyers sticking together. You know, you scratch my back, I scratch yours. True it is that the law as currently stands gives the power for them to attempt an applicable solution. Le linge sale, après tout, se lave en famille, Madame la Présidente. But the law also requires them to refer cases to the Supreme Court whenever there is a prima facie serious breach of code of ethics. And I will give you an example, Madam Speaker, to illustrate my point. And this is within the public domain and concern the Honorable, this August Assembly, because it was a subject of a P&Q last year on the 12th of June 2024. It concerned the conduct of the then Minister of Environment, Mr. Kavidas Ramano. It was established that whilst Mr. Ramano was Minister of Environment, an application was received at his Ministry of Environment for an environment impact assessment. And the application was supported by a certificate, a document under the letterhead of Etude Ramano, signed for Monsieur Kavidas Ramano. There was a clear conflict of interest. You cannot be a minister, be called upon to determine an EIA application, and your own personal notarial practice, l'étude, is signing a letter confirming the ownership of the land subject matter of the EIA application. The more so when the certificate is signed by an employee of that notary public. And according to the reply, the application was made on the 8th of May 2024. That is more than 4.5 years after Mr. Ramano had been a minister. So he can't come and say that these are work that I was doing before becoming minister. So 4.5 years later, his etude, of which he was a full owner, was still operating and issuing applications which are considered by his ministry. Was that normal? Was that ethical? Yet, the chambers of notary refrained to comment. And in the communiqué, they stated, and I quote, cette situation pourrait faire l'objet d'enquêtes et par conséquent, la Chambre se voit contrainte de ne faire aucun commentaire sur cette affaire spécifique. What happened since? Where is the Chamber of Notaries? Have they conducted an investigation? Have they referred have they taken sanction? Have they referred the matter to the Supreme Court? Another example, the case of another notary public, Mr. Vinay Dilchan. There were endless complaints of the public concerning his failure to comply with his statutory duties. In September 2024, the Supreme Court even ordered him, together with another defendant, to pay the sum of 2 million rupees to a plaintiff concerning a fictitious sale. Yet, have you ever heard the honorable, les notables, members of the Chambers of Notaries referring a case of Mr. Dilchan to the Supreme Court for disciplinary action? And the list is long, Madam Speaker. Now, what about the Attorney General? The Honorable Attorney General, I call him the double honorable. Honorable member of an Inner Court and an honorable member of Parliament. I'm taking exception to the honorable incumbent. From 2007 to 2009, there were a few cases where the Attorney General had reported to the Chief Justice cases for disciplinary proceedings, and mostly were following conviction in criminal cases. But no disciplinary proceedings seem to have been reported since 2014 by the then Attorney General. And that's probably, Madam Speaker, because according to their personal ethical standard, there were no professional misconduct. May I remind you who were those Attorney General? The Honorable Yerigadou, l'homme aux honoraires de 32 millions, the minister who was forced to resign over the Bet 65 scandal. Who was the other Attorney General? Honorable Manish Gobin, currently on bail for the offense of public official using office for gratification under in breach of Section 7.1 of the Prevention of Corruption Act. Not so honorable after all. The problem, Madam Speaker, when you give the power to the Attorney General to initiate or not to initiate disciplinary proceedings before the Supreme Court is that you're effectively giving the power to a politician, no offense again intended to the present incumbent, but you're giving power to a politician to use this power to persecute a political opponent or use that power to protect his political allies. That is the problem with the current system. In June 2018, the Commission of Inquiry on Drug Trafficking in Mauritius, chaired by the former Justice Lam Shamling, published its report. It sent shivers up and down the spine of law practitioners. It uncovered a fine-tuned system where certain law practitioners seem to be acting as accomplices for drug traffickers. To cite an extract of the report at paragraph 19.5.3, and that paragraph has not been expunged by any order of the court. It's worth listening, Madam Speaker. The Commission has a very strong reason, in the light of the evidence adduced before it, to believe that there is a handful of barristers who may have acted and may still be acting in a most unethical manner, if not engaging in illicit activities such as obstructing the course of justice, intimidating witnesses, causing witnesses to diverge from their original statement version, thereby abstaining from incriminating certain drug barons, likely to have been they were also likely to have been using drug money to finance political campaigns, possibly money laundering the proceeds of drug trafficking in accepting willfully tainted money, accepting cash beyond permissible amount, and not accounting same in their VAT receipt, and generally fostering incestuous relationship with drug tycoons. And who were those law practitioners cited in the report? Who were the brebis galeuses? Most, if not, were from the MSM party, Madam Speaker. As the Honourable Prime Minister said, qu'à la prison, unsolicited visit to prisoners, mobile phone communication with drug lords serving their sentence in prison. And let me clear something, because in the case of the Honourable Rubina Diadou, she was a minister, so it's directly relevant to this House. She had to resign after her name was cited in the report, and she went to the Supreme Court and asked a judicial review of the finding of the Commission. And on two complaints, namely the phone communication with prisoners and the unsolicited visit, the Supreme Court found no merit in her complaints and held that the decision of the Commission of Inquiry was not manifestly unreasonable or irrational. And what happened? Instead of the Attorney General initiating an inquiry against the lady, the MSM gave her a ticket to run as candidate at constituency number 2 in the election of 2024. Luckily, the electorate, like all of them, threw them out of history. So, Madam Speaker, we can see even under the self-regulation or under the existing Attorney General, it's not working. Legal proceedings, disciplinary proceedings are not being brought against law practitioners. Now, this will change with this bill. So with this bill, we will no longer have self-disciplinary action by the association, the professional association, the Bar Council, the Law Society Council, the Chambers Notary, and no more any power to the Attorney General to decide whether to institute legal proceeding or not. Instead, we are replacing it by a new independent law practitioner complaints commission, which will be an independent body, and it will be under the direction of control of no person or authority. What is interesting, Madam Speaker, with this body, the Attorney General will not sit on any of the inquiries. In fact, there will be a chairperson or a vice chairperson and 2 members of the relevant profession. If there's inquiry over the conduct of a barrister, there will be 2 barristers sitting on the committee. If there's inquiry over an attorney, there will be 2 members of the Law Society. If there's inquiry over the conduct of a public notary, you'll have 2 public notaries. What is also a very important departure from the existing law is today professional misconduct has been defined widely. It does not cover only breaches of the code of ethics, but also covers improper, disgraceful, dishonorable, or unworthy act that has brought his profession or her profession or the administration of justice into disrepute. So that goes wider to just the black letter of the Code of Ethics and also goes in his personal life, the way he has behaved in public, whether that has brought the profession in disrepute. The bill, as the Honourable Attorney General mentioned, has now a set deadline, 6 months to report the complaint and 90 days to complete the inquiry. This is most welcome because for those law practitioners who want to clear their names, it is very important that there is a set time frame to do so. Another important change, the disciplinary proceedings will now be heard in front of a bench consisting of 2 judges, and the aggrieved party can appeal to the Court of Civil Appeal. This is a major difference from the current practice where disciplinary hearings are heard before 3 judges and the appeal is to the Judicial Committee of the Privy Council. Madam Speaker, the legal profession of which I am a part of is in its very essence a very noble profession. And it goes, or at least should go, without saying that those admitted to this profession must uphold the highest ethical standards and a top-notch professional conduct. Regrettably, even in the most respected profession, there are a few whose conduct tarnishes the reputation of the many. This bill is not just a legislative reform, but a structural safeguard for the rule of law, for fairness, and for equal accountability, whether the lawyer is well connected or not. Thank you.
Thank you, Mr. Honourable Attorney General. I know you don't like me saying winding up speech. I just checked. It's perfect English. But I will ask you to round up.
Madam Speaker, there is a well-known line from Shakespeare that is often quoted. And let me hasten to add that before I actually spell out the words, that I do not approve, of course, of its contents. It's spoken not by reformers in the play Henry VI, but by those plotting to destroy the rule of law. And it goes as follows. The first thing we do, let's kill all the lawyers. The meaning is very simple. If you wish to collapse a society, you begin by silencing those who know the law, who defend rights, who safeguard due process. Far from being an insult to the profession, The line just quoted is just a reminder of the centrality of lawyers in any functioning democracy. Madam Speaker, this is why the bill before the House today matters. It recognizes that the strength of a democracy is tied to the strength of those who serve justice, and it recognizes that confidence, public confidence, is the bedrock on which the legal profession must stand. If at this stage I could respond to my learned friends who have addressed the House today. To the Honourable Ramdas, I will draw attention to the fact that Section 15, subsection 2c, clearly spells out that the disciplinary proceedings before the Supreme Court shall be conducted in the same manner as proceedings in a civil matter. And of course, that is on a balance of probabilities. The suggestion that lawyers should be treated differently from any other professional being placed before a disciplinary committee under the Workers' Rights Act would not sound very good. If it's good for everyone else, it should be good enough for us. As far as my learned friend Lubin, Honourable Lubin's comments are concerned, I take on board the suggestion of the complementary mechanism of the legal ombudsperson, but I do think that at this stage, and I take his point, that we should perhaps look at this in the future if ever we have this administrative overburden on the system. For my friend, on the part of Honourable Utim, let me say that I have nothing to add. The vast majority of our attorneys, barristers and notaries, Madam Speaker, serve with dignity and competence, but we must acknowledge an uncomfortable truth. Confidence has been shaken, not because the profession is corrupt, because the system for dealing with a few cases of misconduct has not kept pace with modern expectations. The bill is not a reprimand to the profession. It is an act of respect, an act of commitment, an act of confidence. It says clearly, your honor matters, your role matters, your credibility matters, and we will help you protect it with a system that works, that is transparent and independent. Our government, Madam Speaker, has promised to renew the foundations of our institutions. We have said that democracy must be strengthened not only in its ground principles, but in its everyday workings. A justice system cannot be credible if citizens doubt whether misconduct in the legal profession is treated impartially. Nor can it inspire confidence if lawyers themselves feel that well-intentioned colleagues are tarnished by the acts of a few. The bill answers those concerns with balance and clarity. Madam Speaker, a society that values the rule of law must also value those who practice it, and valuing them means helping them uphold the highest standards. That is what this bill does. It protects the many from being stained by the few. It protects citizens who seek justice, and it protects the integrity of the three professions, and that is indispensable to the health of our democracy. I thus commend the bill to the House.
Thank you. So the question is that the Law Practitioners Disciplinary Proceedings Bill be read a second time. Those in favour say aye. Aye. Those against say no. The ayes have it.
Committee stage.
C'est le nouveau que tu m'as donné. C'est bon.
Amended, no?
Oui, the amended. Yes, you may be seated.
Clause 1, short title. Clause 2, interpretation. Clause 3, non-application of act. Clause 4, establishment of complaints commission.
One moment. The question is that clause 1 stands part of the bill. Those in favour say aye. Aye. Those against say no. The ayes have it. Qu'est-ce qui s'est passé? Clause 2. This is the amendment, right? I'm sorry. It's not as simple as in court. What I have here, I have to move that clause 2 be amended. No?
No, just give me a second.
Il y a un problème, hein? Excusez-moi.
Madam Speaker,
Yes.
the first amendment is at clause 5, so 1, 2, 3 and 4 should
Yes,
go
all
without
right.
amendments.
So this is no good. Okay, let me just say, and then you tell me. The question is that clause. I've already said 1. Now clause 2, 3 and 4 stand part of the bill. Those in favour say aye. Aye. Those against say no. The ayes have it. Now we go to clause 5.
Clause 5, compulsion of complaints commission.
Madam Speaker, I move that clause 5 of the bill be amended as per amendments circulated today.
The question is clause 5.
Okay. The question is that clause 5 be amended. Vous n'avez pas l'amendement?
Yes.
We should have.
Yes. Just put the question that the clause 5 be amended as per amendment circulated.
Okay. The question is that clause 5 be amended as per the amendment circulated. Those in favour say aye. Aye. Those against say no. The ayes have it. That was clause 5. Attends, maintenant, on va faire... Non, celui-là, c'est ma faire. I'm going to do it by myself. The question is now that clauses 6 to 8 stand part of the bill. Those in favour say aye. Those against say no. I didn't hear any. The ayes have it. I know it's late, not that late. 9.
Clause 9.
Now there's an amendment.
Madam Speaker, I move that clause 9 of the bill be amended as per the amendments circulated today.
Question is that clause 9 be amended as per amendment circulated. Those in favour say aye. Aye. Those against say no. The ayes have it. Il n'y a personne. Bon. The question is that clause 9 as amended stands part of the bill. Those in favour say aye. Those against say no. Aye. The ayes have it. For clause 5, we didn't do that part. I'm sorry. I'm going back for clause 5. I have to go back for clause 5, just to make sure that we're doing it the right way. The question was that clause 5 as amended stand part of the bill. Those in favour say aye. Those against say no. The ayes have it. C'est juste qu'on n'a pas fait les deux morceaux. Vous avez l'habitude maintenant. Moi aussi, mais bon.
Clause 10, conciliation by complaints commission. Clause 11, investigation by complaints commission. Clause 12, caution by complaints commission. Clause 13, no evidence of professional misconduct. Clause 14, institution of disciplinary proceedings. Clause 15, inherent powers of Supreme Court. Clause 16, interim order of Supreme Court. Clause 17, disciplinary powers of Supreme Court. Clause 18, appeal. Clause 19, protection from liability.
Okay. Now the question is that clauses 10 to 19 stand part of the bill. Those in favour say aye. Aye. Those against say no. The ayes have it.
Clause 20, consequential amendments.
Speaker, I move that clause 20 of the bill be amended as per the amendment circulated today.
Okay. Question is that clause 20 be amended as per amendment circulated. Those in favour say aye. Aye. Those against say no. The ayes have it. Question is that clause 20, it's always en deux morceaux. So now the question is that clause 20, as amended, stands part of the bill. Those in favour say aye. Those against say no. The ayes have it.
Clause 21, transitional provisions. Clause 22, commencement.
That was 21 and 22. The question is that clauses 21 and 22 stand part of the bill. Those in favour say aye. Those against say no. The ayes have it.
30, enacting clause.
The question is that the title and enacting clause stand part of the bill. Those in favour say aye. Those against say no. The ayes have it. Now the question is that I do report to the House that the Law Practitioners Disciplinary Proceedings Bill number 29 of 2025 has passed the committee stage with amendments. Those in favour say aye. Aye. Those against say no. The ayes have it. Thank you. Sorry for Mr. Kapida. One moment, you may be seated. Alors, je dois me retrouver. Okay, honourable members, I have to report to the House that the Law Practitioners Disciplinary Proceedings Bill number 29 of 2025 has passed the committee stage with amendments.
Third reading.
I move that the Legal Practitioners Disciplinary Proceedings Bill number 29 of 2025 be read a third time and passed.
It's seconded? Yes? Question is that the Law Practitioner Disciplinary Proceedings Bill number 29 of 2025 be read the third time and passed. Those in favour say aye. Aye. Those against say no. The ayes have it. Honourable Prime Minister, adjournment.
Madam Speaker, I beg to move that for the adjournment of the House to Tuesday, the 9th of December at 11:30 a.m.
The question is that the House be adjourned to Tuesday, the 9th of December at 11:30 a.m. Those in favour say aye. Aye. Those against say no. The ayes have it, and the House stands adjourned.